Hello, everybody. Can you hear me? If you can type in the chat box that you're hearing, just let me know. I'm seeing some yeses from the panelists. Okay, so we'll go ahead and get started on this. And I see we already have a question. Okay, so we're going ahead and get started on the webinar today. My name is Paul Geringer. I'm the Extension Legal Specialist here with the University of Maryland, and our first webinar in our series of ag law webinars is on sort of some of the issues that have been faced with dicamba. And we're going to kick off with Matt Morse, who is an ag educator here with the University of Maryland Extension in Frederick County. He's going to talk a little bit about the background and history with the dicamba products on the market, and then we're going to hand it off to Tiffany Lashmet, who is a legal specialist with Texas A&M Agrilife Extension, and Kelly Nuckolls, who is also a legal specialist here with the University of Maryland, to discuss some of the issues that have come up legally once this product has gone on the market. And if you have any questions throughout this webinar, just type them in the question box, and I will try to remind the speakers to look at that as well. And as long as I don't see anything, I will go ahead and get this started. So I will hand it off to Matt. So.
All right. Thank you, Paul, and thank you for having me do this. So like Paul said, I'm Matt Morris. I am an ag agent here in Frederick County, Maryland, and just want to touch, for the next 15, 20 minutes on a little bit of the background and history of dicamba. So what is dicamba? Well, obviously it's a herbicide. We call it a benzoic acid herbicide is the type of family that it's in. One of the unique things about it is that it is a selective herbicide. And what I mean by selective, it only kills certain types of weeds. We think of glyphosate or Roundup as non-selective. It pretty much kills every plant except for resistant ones. Dicamba is only going to kill broadleaf weeds. It will not kill grasses. So that's one unique thing about this product is no activity on grass. It's been one of our staple herbicides in hay and pasture, as well as corn, any small grain production, pretty much any grass crop production. It's also used a lot in burn down, in different parts of the country for soybeans even, prior to the crop being planted. So, like I said, throughout the years, it's kind of been the backbone of grain production, especially with corn and small grains. That gave us the ability to, both before the crop was planted and once the crop was growing, to go in and take out broadleaf weeds, whether they be broadleaf weeds in corn, or if you had chickweed in a winter small grain crop, like we grow a lot of winter wheat here in Maryland. For pasture and hay production, like I said, it's really been the go-to product. Usually dicamba and 2,4-D are the products that have been used on hay and pasture. That's why this whole thing with dicamba being in the news, it kind of worries people even if they're not involved in dicamba-tolerant soybeans, because it's one of the staples. It's what we rely on. One thing about those production systems that it's been used in is generally we're using them either in the spring or the fall. With hay, we're always spraying our fields early spring before our grass really starts to take off and get too big. With corn, generally, we're planting in April, so we're either spraying, early April or maybe into May sometimes, but generally what we think of as cooler temperatures. And as we know, the hotter the temperature gets, the more volatile dicamba becomes. Just like when you take the lid off a can of gasoline and that vapor comes out, dicamba is the same way. And if you can get a whiff of it, a sensitive crop can get a whiff of it. So I've always been spraying these things in cooler weather, and that volatility has never been an issue. As I'll talk about here in a second, soybeans are sprayed a little bit later in the year, generally in hotter times of the year. So as new tolerant crops open up new application windows. That's why we're seeing some of these issues. So the history and background of it is not a new product. It was first commercialized in 1964. And you can see this timeline here on the bottom. Discovered in 1958, Banville was the first trade name for dicamba that came out. Progressed through the years, we had Marksman and then Clarity. As these products go on, you know, Banville all the way up to Clarity, what those were doing were reduced volatility formulations. Banville was just really, it was really good as far as the herbicide goes, but it was really ornery because it was pretty volatile. It was hot stuff, that's for sure. Then obviously more recently we've had the dicamba tolerant soybeans. 2017, last summer, was the first year that we could utilize those here in Maryland. Just a figure that I had gotten, 20 million acres of these beans went in nationwide last year. So, you know, it's not a new product, but dicamba tolerant soybeans are. So, like we said, you know, this whole conversation and the reason we're doing this today, you know, it's not because all of a sudden dicamba is a new big thing. Like I said, it's been out since 1964. We probably would have talked about this 40 years ago if it was a problem. But these dicamba tolerant soybeans, while they're not a problem, they do, you know, have some issues associated with their use and some areas for concern. So what's really driving this? Well, the herbicide resistance is driving this. We needed a way, or farmers needed a way, and the companies responded to control these glyphosate-resistant weeds. You know, not only glyphosate, ALS products, you know, several different types of chemistry these weeds are becoming resistant to. And modifying soybeans to be resistant to dicamba, which the weeds have no resistance to, was the answer that the companies came up with. So across the U.S., we're looking at 150 different confirmed herbicide-resistant weeds. Mare's tail, that's a big one. Horseweed's another name that it goes by. That's one weed that the Mid-Atlantic can claim as its own. We kind of gave that to everybody else that originated here. That's resistant to glyphosate, which is Roundup, Paraquat, or Gramoxone, and then the ALS chemicals, which there's a whole bunch of them. Palmer, amaranth, that's a nationwide problem at this point. I was walking a field of it yesterday at a neighbor's. It has resistance to glyphosate, the dinitroanilins, HPPDs, PPOs, and ALS, all sorts of different chemicals. And water hemp, which is just about as bad as Palmer, similar species, they're both pigweeds. That's been confirmed resistant to much of the same chemistry as Palmer amaranth. So this is why people were looking for an answer. You know, I think there's probably some more management tactics they can do instead of falling back on some more herbicide-resistant traits, but this is what we've gotten. So just looking at Maryland, you know, here in Maryland we have 14 different herbicide-resistant weeds. You go all the way back to 1979 when we had smooth pigweed was showing resistance to atrazine, all the way up until water hemp being confirmed here in Frederick County last year. So a little bit of the terminology, and most probably know this, but I still get this a lot, is everybody wants to call dicamba Banville. Doesn't matter what it is, it's Banville. I guess that's what everybody grew up with. So it is not Banville. I've also heard people call it 2,4-D. It is not 2,4-D at all. They both kind of work on the plant in the same way. They're in the same group of herbicides. But if you're going to use these Roundup Ready soybeans or the Roundup Ready Extend crop system, there are 3 products that you can use. I think there may actually be a 4th now. You can only use Ingenia, which is BASF, Fexapan from DuPont, or Extendamax with Vapor Grip technology from Monsanto. So, you know, this is a slide I took from one of my winter meetings, just trying to get people to understand, okay, these are the products you absolutely have to use. Yeah, Banville won't kill the beans, but, you know, I'm sure somebody's going to talk about the hot water you'll be in soon if you were to use that and have an issue. So what's the good about it? You know, there are a lot of good things that these dicamba-tolerant soybeans have done. Like I said, dicamba has very little herbicide resistance because it really works on the plant in such a unique way that's hard for a plant to overcome. It then makes it possible to apply dicamba in crop. Traditionally, on just a regular soybean, if we sprayed dicamba on it, it would kill the weeds and it would kill your beans too. But you know, now we have an effective herbicide to use within the crop of soybeans. It's effective on mare's tail and palmer amaranth. Those are the two big complaints that we get and the weeds that growers really struggle with. And I say there's no confirmed resistance to dicamba, but there's some areas, especially in the Delta region in Tennessee, where they are showing, you know, they may be getting, I don't want to say it's full-blown resistance, but it's tolerance. Fields that were getting 100% control with dicamba are now down to like 80% control. Palmer's a very diverse, tough competitor, so it would not surprise me if we had resistance to it within the next few years. It really only took mare's tail about 4 seasons to develop glyphosate resistance, which is quick in the scheme of evolution. You know, here's the good about it. This was a Monsanto plot. On the right-hand side, these are dicamba-tolerant soybeans. They were sprayed with Extendimax. You can see they're really clean. The left-hand side of this frame, it is loaded with palmer amaranth. Those were the untreated plots where they did not spray dicamba. They only sprayed Roundup. And you can see it's hard to make out the soybeans in there. You know, there's a lot more good than that. I have a lot of slides on the bad. I don't want people to think I'm just, you know, downplaying or talking bad about them, but you know, there's a lot of concern. So we all know there's issues associated with this technology. One thing is the movement of this product's unpredictable. You know, we can lose it through drift. We can have volatility, temperature inversions. You know, a lot of crops are really, really sensitive. Non-crops, you know, woodlands, all sorts of things, you name it. Rose bushes in someone's front yard, everything, you know, pretty much if it can get a whiff of it, it's going to show some symptomology. The other bad thing, like I mentioned, this technology is now putting our application during the warmer parts of the summer. These are just some pictures here of dicamba damage. The top left, that's dicamba on soybeans. Then the top right, those are grapes. And then the bottom, we have a tomato plant there, all showing dicamba symptoms. So I'll just run through these real quick. I don't want to take up the whole time, but you know, these were some work that we did where we sprayed dicamba on non-tolerant soybeans. The first pictures are different growth stages, and we sprayed a full rate as if someone sprayed the wrong field. You can see when we sprayed them at the first trifoliate, it killed all of them. Over on the left and then behind, you can see those are untreated plots. That was sprayed third trifoliate, you know, maybe 6 to 7 inch plants. They're killed them pretty good. Go down 8th trifoliate, you can see there's some dead bean carcasses there, but it pretty well finished them off. Then this was early flowering. It pretty much wiped them out as well. Early pod fill, that's when the beans were filling out in the pod. No harvestable yield on those plots. Then what we did was different rates. This was a full label rate of a pint per acre on a set size of soybeans, about 6 to 8 inch beans. You can see the pint killed them. This was a 64th of a pint. You can see that the beans are all cupped up and there was no yield on those plants. Even though it didn't officially kill them, there were no harvestable pods from those plants. This was 128th of a pint per acre. We had to put that in the tank with an eyedropper. And you can see they're crinkled up real good, and we actually lost half of our yield with a 1/28th of a pint per acre. So, result of that work, dicamba, anytime you apply it, no matter the growth stage, you're going to get no yield. And like I said, the 1/28th of a pint per acre resulted in half the yield. This is a nice thing University of Georgia did. This was basically the amount of dicamba it took to show some sort of visual injury on a plant. So the lower one, all the way over on the left, you see in green, broccoli, cabbage, kale, mustard. It took 1/75th of a label rate, or 1/75th of a quart per acre of most dicamba products to show injury. If you go all the way over on the right, grapes, lima beans, and then you go down soybeans, sweet potato, tobacco, they only took 1/800th of a quart per acre to show some sort of visual injury. You know, and that's an extremely low rate. I'm not even sure how they could measure that out. So just that kind of shows how sensitive some of these crops are. Cotton is in the severe, tomatoes are in the severe category, so they took, you know, 300th to an 800th of a pint, or a quart, excuse me. So there's a couple different ways this injury is occurring. Drift, obviously, is one of the big ones. This is when the wind is carrying these droplets off target. I always say this is the easiest one to correct because it's entirely in your hands. Nozzle selection, obviously using the right nozzles, which are required by the label. Knowing your wind speed, your wind direction, and your surroundings. You know, if something doesn't match up right, then don't spray. That's how you can avoid drift. Volatility, this is the most unpredictable one. This is where dicamba turns into a gas after application. It lays on those leaves, and it can actually re-gas off the leaf surface. And this can happen up to several days after application. Warmer temperatures increase this risk, but you know, the new formulations are claiming reduced volatility. Thing about it is, it's hard to control. If you spray on the most perfect day as far as everything else goes, you know, no volatility, it's cool that day, you know, how do you control the temperature or the conditions for volatility, you know, day 2 and 3? Especially if there's rain coming, you know, day 2 and 3, you're going to spray. Temperature inversion, that's another one. This is where the ground, or the air ground level is cooler than the air above, and those fine spray droplets just kind of hang around. That's why you see the label has changed now. You can't spray below 3 miles an hour, because that's going to usually indicate a temperature inversion. You can see the picture, that's fog hanging there. That's what those droplets will do. And they'll hang there until the wind picks up, and then it will move that mist or that fog that hangs above the field over to a potentially sensitive crop. Conditions that favor it, like I say, still air, clear, still evenings, or a foggy, cool morning. And then spray tank contamination. This is another one that's pretty correctable. It's hard to clean the entire spray system out sometimes, but you can see in the picture here that machine got cleaned out when it got to the end of that first pass there, and that was contamination in that tank. One thing about it, if you add glyphosate to a tank or Roundup, that is an excellent tank cleaner, and it will strip all that dicamba residue out of your system for you. You know, now the label's requiring triple rinse and documentation of such, but is that enough is my question. I don't know if in all cases, as boom systems become more complicated, I don't know if that's going to be enough. And we've probably all seen this. This was the dicamba-related injury investigations for 2017. You can see, you know, total was about 3.6 million soybean acres. This was compiled by University of Minnesota. You can see, you know, that Mississippi Delta region, Arkansas, Missouri, Illinois, you know, they had some serious issues, and I was able to go down to Arkansas this past September, and they had quite quite a problem down there. So that's all I have. Are there any questions?
I'm not seeing it in the question box currently, so I will hand off the speaker duties to, or presenter duties to Tiffany.
All right. Thank you, guys. Thank you, Paul.
Thank you, Matt. And I think, Tiffany, you are now the presenter, so I'll hand it over to you.
All right. Well, Paul, thanks for letting me come and speak today. I want to tell you guys I've listened to a lot of folks talk about dicamba and kind of explain the issues, and Matt is one of the best that I've heard. So you're lucky to have been able to hear him give that overview that he just gave. I'm going to talk today a little bit about some legal issues between farmers and applicators. And these are not dicamba specific, although certainly it's no surprise given the number of drift claims we've seen on that last map that Matt showed, that we have some of these in the dicamba realm. But these are the ones that come up, right? When somebody sprays and there's drift that occurs, what kind of litigation do we see between the farmer and the applicator? Now, keep in mind, the applicator may be another farmer, or it could be like a contract aerial application company. And so we're going to talk a little bit about those cases before we let Kelly talk about some of the specific dicamba-related cases. So when we see drift cases occur across the U.S., there are kind of 4 potential legal claims that we see, again, and this is between the damaged party and the applicator. I'm going to walk through each one of these one at a time and kind of talk about what they are. Generally, the most common is negligence. Negligence is pretty simply explained as failure to act as a reasonable person would under the circumstances. I always tell people any sort of negligence case, you can just sort of think about a car accident case. Same claims as a car accident or spray drift if you're talking about negligence. Strict liability, we see that applied sometimes when we're dealing with pesticide application. And basically what that is we impose liability on someone if an injury occurs regardless of the facts. We don't care if the defendant acted reasonable or not. The third type of claim that we see periodically is trespass. That's the physical invasion onto the property of another. And then there are a couple of nuisance cases that have been brought. Those, I think, have been kind of confined to Arizona. And a nuisance is an interference with another's use and enjoyment of his or her property. And so we'll talk through each of these. Like I say, it matters which claim you bring because they each require different elements of proof and may be subject to different defenses as well. So for a negligence claim, like I say, these are by far the most common for drift cases. Likely anytime someone sues for drift, they're going to claim negligence, even if they're going to claim something else as well. They're very fact specific. And that makes sense because, like I say, the question is, did you act like a reasonable person under the circumstances? That kind of requires a factual inquiry. The elements that have to be shown in order to prove negligence, the first one is duty. That's a relationship between the plaintiff and the defendant such that this duty to act reasonably arises. That's generally not an issue in a drift case. Breach of duty is the second element, and what the plaintiff here would have to prove is that the defendant did something that was unreasonable under the circumstances. And that's where those facts come into play. We'll look at a couple of cases here in just a minute. Breach of duty always going to be an issue likely in these cases. One of the best pieces of evidence to show a breach of duty for a plaintiff is pretty simply to show they violated the label. You know, like Matt was talking about, if you're spraying Banville over the top of the new Extend soybeans, you have violated the label. That's pretty easy to find a breach of duty in that situation. The third element they have to prove as a plaintiff is causation. That's just simply that the defendant's breach was the cause of the plaintiff's injury. That can be easier said than done. We saw some situations, particularly across the South. You'll hear from Kelly in a minute. Arkansas has kind of been ground zero for these types of claims. But let's say that there were 10 people, you know, in a certain radius to your farm. They all sprayed some form of dicamba, and your crop was damaged. Proving who caused the damage can be very difficult or even impossible, and so that causation element can be a tough one for folks making these claims. The final element you have to show is damage. You've got to prove that damage occurred. This can be interesting, and there were a couple of cases, again, from Arkansas that were filed where a farmer versus farmer type case, there was damage to the crops. You looked at the pictures. No question there was significant damage to the plants, but then when harvest time came around, they harvested the soybeans and actually yielded better than their 5-year average. Kind of difficult to prove damages in that situation where maybe the leaves and the plants looked awful, but there weren't monetary damages, and so that's something that folks have to prove. Here's an example of a couple of cases, and these are from Texas, which is where I'm located, but I think they're a pretty good illustration of how the facts really come into play. In the first case, a farmer's employee applied aerial spray for boll weevils and cotton. A neighbor claimed personal injury from the drift. They said it made him ill and caused some health problems. In that case, the court sided with the farmer, the applicator, and basically said there was no evidence that the applicator acted unreasonably. Wind speed was less than 10 miles an hour. He inspected the airplane before he left the airport. He had a ground observer to monitor wind speed and direction and watch out for people. And the pilot flew the field before applying anything to ensure safety. Those are the kind of facts you want as a defense lawyer in these type of cases. Let's flip that and look at the kind of facts a plaintiff lawyer wants, and that's the Boyd case. In that case, a neighbor sued an applicator for drift after the neighbor's cotton field was damaged, and the court sided with the neighbor. So the court sided with the plaintiff. Because it was a windy day, the pilot admitted that he knew the pesticide could drift. He knew the label warned against using the product near cotton, and the chemical was actually smelled by witnesses on the neighbor's field after it was sprayed. Not facts the defense lawyer wants to have. And so that's just an example of how the facts really play into a negligence case. Our second claim that we see is strict liability. And essentially what strict liability says is there are some activities that are just so dangerous, we're imposing liability regardless of how careful you were. And so, I don't know, the classic law school example of this is if you have a tiger in a cage in your backyard, we're probably imposing strict liability. And it doesn't matter how tame the tiger is or how many locks you put on it or how many fences he's behind. If the tiger injures someone, you're liable because having a tiger is inherently dangerous. So the question then becomes with regard to spray drift, is application of pesticide an inherently dangerous activity? The answer to this can be a big deal, obviously, because it's pretty severe to say that no matter how careful you are or what precautions you take, if drift occurs, you're liable, period. And courts across the country have looked at this issue. Here's a collection of the opinions I have been able to find. I did not find anything in Maryland. Louisiana, back in the 1950s, has said they did apply strict liability for the aerial application of 2,4-D. In 1961, Oklahoma imposed strict liability for aerial application of pesticide on a cotton field. Washington applied it for aerial application. In 1977, Wisconsin refused to apply it for aerial application of 7 on a cornfield in 1984. New York in 1994 said that it was not inherently dangerous. And Arkansas in 2014 said crop dusting was not inherently dangerous. I want you to look at a couple of themes here. The first one is most of these cases involved aerial application. So I think there could be a question here of if we're going to say aerial application is inherently dangerous, are we going to make a distinction between aerial and ground application? And is it by virtue of spraying from an airplane we find it inherently dangerous versus ground application? That distinction could be very important from a dicamba standpoint, obviously, because dicamba is not approved for aerial application and is ground application only. The second trend I think we need to look at here is it was older cases that have applied strict liability. The more recent cases looking at this have not. They have said it's not inherently dangerous. In that Arkansas case in 2014, they specifically said, listen, this is not some new technology now. It's done all the time. It's so common. We're not going to say it's inherently dangerous. So I also think query, would the decision be different today than it might have been 60 years ago? I think that's something at least to consider as well. Our third claim is trespass. This one is frankly more rare, but we've seen it here in Texas, and so I think it's at least worth mentioning. Texas occurs when a person or a substance enters the property of another without their consent. I think everybody's pretty comfortable, right? If I crawl over Paul's fence and go walking through his cornfield, I'm trespassing. But what if particles of a pesticide cross Paul's fence and enter his cornfield? Can those pesticide particles be the substance that trespasses? There have been courts that have said yes. Again, I didn't find anything on this in Maryland. Paul, correct me if I'm wrong and there's something I just didn't come across. Here in Texas, there has been a successful trespass case. In that case, the flood control district was going around and they were spraying herbicide in bar ditches to kill the weeds. They drifted onto a cotton farmer's field, and the farmer sued the flood district for trespass. The farmer was successful there, and as you can see, this could be a potential alternative claim to nuisance. To negligence. If potentially you couldn't prove negligence, maybe the sprayer did act reasonably, trespass could be a potential alternative claim because you don't have to prove unreasonable action, just that entrance without consent. A potential defense to this, an ag operation, if it was an ag operator who was applying the pesticide, they potentially could argue that the right to farm statute would apply and as a defense. Those statutes really differ by state. There's different things that you have to prove. One of them that's pretty common in every state is you have to show that you are not operating negligently or in violation of the law. So again, if you violated that label, that means that you probably can't rely on that right to farm statute defense. The other thing to look at is your individual state's right to farm act. Here in Texas, you have to have been in operation for a year, so you would have to show you were applying the pesticide, potentially the same pesticide or at least the same way, ground versus aerial application for more than a year. Again, that's a potential problem when we start looking at dicamba, since over-the-top application of dicamba is fairly new. The last claim I'll mention is nuisance. This is very rare to see. A nuisance occurs when the defendant's action interferes with the plaintiff's use and enjoyment of their property. Commonly, we see nuisance lawsuits dealing with odors. If a dairy or a pig farm, if you guys have been following the news in North Carolina, if there are neighbors nearby, they may claim nuisance having to do with odors or dust from a feedlot or noise from equipment. That's more common what we see. There is a line of cases out of Arizona that indicate a nuisance claim may be possible for pesticide drift. I only saw that in Arizona, but it's something to at least keep in mind. Again, that potential right to farm defense exists there as well. The last topic I'm going to cover briefly here before we turn it over to Kelly is liability for a hired contractor. I have gotten a couple of questions on this in the last week, so it's certainly something that's on the mind of folks on the ground, at least here in Texas. So the general rule, if I go hire an independent contractor to come spray for me, right? So my brother, for example, works for an aerial application company. They spray for everybody. You hire them, they own the planes, they hire the pilots, they mix the chemical, they just come spray for you, then they go spray for somebody else. That's likely an independent contractor. And the general rule is you are liable for the acts of your employees in the scope of their employment, but you're not liable for the acts of an independent contractor. So like I say, if you're hiring out somebody like an aerial spray company, courts are likely going to find those are independent contractors. If you've got an employee, right, if you run down to the store and you purchase your dicamba and your employee drives your tractor and you mix it and you tell him how to spray it and where, now you've probably got an employee. So you have to think about whether or not you're dealing truly with an independent contractor or employee when you're talking about liability. Like I say, if it's an employee, you're liable for his or her acts during the scope of employment. A hired contractor, independent contractor, you're likely not liable for them unless there's an exception. Generally, you can be liable for the acts of an independent contractor if the activity is inherently dangerous. Sound familiar? We keep coming back to this, right? As defined, at least here in Texas, and most states are pretty similar on this, an inherently dangerous activity is one that is dangerous in its normal, non-defective state and would probably result in injury to a third party. So when we think about that, is spraying chemicals on crops something that is dangerous in its normal or non-defective state that would probably result in an injury to a third party? That would be the question. At least 11 states say yes, that applying pesticide to crops is inherently dangerous. You'll see here Maryland is not on the list, nor is Texas, where I am from. But that's something to keep in mind. That's an issue that comes up, and it's going to just kind of depend on your state how they look at that. Again, I think that the same questions apply here with regard that we talked about with strict liability. You know, more recently, if we're talking about cases from the last decade versus 60 years ago, I feel like it's probably going to be less likely for them to say they're inherently dangerous because pesticide use is so prevalent now. I also think that there could be a distinction between aerial versus ground application. I think that can be important. But an issue that could be a big deal, and I think folks need to at least be aware of that. The other thing I'll say here is the idea of, you know, can you apply a pesticide safely? I think most of us would say, well, yeah, you know, I mean, people apply pesticides safely every day. When we look at the number of complaints about dicamba, again, particularly across the South, there have been at least some studies or some, you know, researchers who have said, hey, I don't think that this could be applied safely no matter how you do it. I'm not the weed scientist, so I have no opinion on whether that's accurate or not. But that kind of issue could sure have an implication when we're talking about strict liability and liability for an independent contractor. So I think that's just something to keep in mind. With that, I'm ready to turn it over to Kelly. I'm happy to take any questions if anyone has them now, or I'll stick around if you have questions at the end as well.
I should say I am not seeing any in the chat box or the question and answer box currently, and I will work on getting Kelly, handed it over to Kelly as the presenter. She should now be the presenter. So Kelly, I will hand it over to you and let you take it over.
Thank you, Paul. So I'm going to talk about several of the dicamba cases that are currently being litigated right now related to these new products. You've probably seen some of them in the headlines, but I probably won't have a lot of time to go into detail, so keep that in mind that this is a general overview of where the cases are currently. So here is a list of the main cases that you've probably heard about or seen in the newspaper headlines. The first one is a multi-district litigation of about 20 different class action cases right now. They've been adding more almost each week lately, so that number could increase in the future. But with these class action cases, a bunch of farmers that have received crop damage allegedly from these new products, and they are suing the companies that release these new products. So that includes both Monsanto's release of the non-tolerant or the tolerant dicamba seeds, and the new dicamba products as well. So they're suing both Monsanto, BASF, and DuPont in these cases. The second one is a little different, but it's actually being heard by the same judge in the same court currently because the facts are so similar. This is farmers that actually purchased the new dicamba products and the dicamba tolerant seeds and were unable to use them. These farmers were located in Arkansas, which actually banned the use of some of the products for 2017 and currently have a ban on the new dicamba products. So with this, a little bit different. These are farmers that actually wanted to use the products and purchase them, but were unable to. Then in the state of Arkansas, like Tiffany mentioned, that's kind of been the hot spot for all the dicamba issues this year. So there are some cases where both Monsanto and farmers that want to either sell or use these new dicamba products in the state of Arkansas are suing the state plant board, which has enacted this ban on all new dicamba products from April 16th to October 31st. You are unable to spray those new products in the state of Arkansas currently during those dates. And then a quick overview of the last case. This is a case brought by several organizations, including the National Family Farm Coalition, that they're actually suing the EPA for approving these new dicamba herbicides for use on the market, and so they're trying to get that approval rejected in federal court. So going back to those class action cases that are in the multi-district litigation right now, there are some different issues depending on when farmers actually had damage, whether that was 2015 and 2016 before the new herbicide products were released, but Monsanto's tolerant seeds were on the market during those times, and then the year 2017 when there's alleged damage possibly from the new herbicide products. So with that, I like to think of it also in a way of comparing the amount of damage. So before those new dicamba products were released and the seeds were all that was available, there was a lot less damage. So in Arkansas, for example, there's only about 24 reports. And then once the new herbicide products were released, of course, a significant amount of damage, over 900 complaints in the state of Arkansas alone. So it's a little bit different, and the court also sees these different years a little bit differently, in part because of the fact that Monsanto and some of the other companies do not sell this old dicamba product that it's alleged that certain farmers were using on tolerant seeds before the less volatile products were released. So that's something to keep in mind when you're looking at how the court's looking at different issues related to this case. Tiffany mentioned negligence and the idea of needing causation to prove that, you know, something under your control actually caused the damage, and that's a big issue here with these cases because of the fact that Monsanto did not sell that old dicamba that actually allegedly caused this damage to these crops in 2015 and 2016 before the new less volatile products were released. So that's something to just keep in mind when you're looking at what the court's deciding. So with that, and in this multi-district litigation, the court has already ruled on a couple of pretrial motions. The first one was from BASF, and they were trying to dismiss claims against them. Specifically, the court looked at, in this order, the plaintiff's negligence-based counts during 2015 and 2016, because BASF did not have a dicamba herbicide approved on the market until December, as you can see, 2016. So they're arguing that it did not cause any damage, and therefore it fails the causation element that Tiffany mentioned. So with this, the court looked at it and said the only way that you could be liable, since your product was not on the market until later on in that year, and it wasn't on the market in 2015 at all, the only way you can be liable is to prove a conspiracy between BASF and Monsanto to release these tolerant seeds at a right time before the new products were even approved. And of course, whether or not the facts can be proved at this point may not be as big of a consideration for the court, but here the court specifically looked at this negligence issue and whether or not they could prove that. And the court said that it is hard to prove that they actually caused it. So the court actually dismissed all negligence claims related to BASF during 2015 and 2016. The court said that they could still be liable for an intentional tort. So like trespass, Tiffany mentioned how trespass can happen in some of these claims with pesticide drift. And so here they said trespass may still be a viable claim as well as civil conspiracy if you can prove with evidence that it actually existed. And they can still assert negligence claims, of course, for 2017 when their product was on the market. So the big takeaway from this order is BASF cannot have any negligence-related claims against them during 2015 and 2016. The second big issue that the court in that multi-district litigation has decided is related to Monsanto's motion to dismiss some claims against them. And again, that causation element in negligence was key here. Here, Monsanto is arguing that, you know, for 2015 and 2016, the old dicamba products that caused this damage, we did not sell them, so there is no actual cause that we created that had this damage. But the court said that this is a very unique case. Whether or not they actually manufactured the old product does not matter, because the plaintiff's negligence theory is that it was foreseeable that farmers might possibly spray the old dicamba products when they released these dicamba-tolerant seeds on the market before an approved herbicide. So with that, the proximate cause is the main issue here. So whether or not the release of those seeds is the primary cause of this third-party action from farmers spraying an old dicamba product on those seeds. And so here, the court said that there's not a lot of legal precedent to prove this, but it's probably something that is best left for the jury to decide, because it is possibly foreseeable that, farmers may want to use the old dicamba products on these dicamba-tolerant seeds during 20 and 26, and that it's possible they could have seen this behavior happening. So this is a claim that will continue on, and the jury will be able to decide in the future. With the class actions, again, several cases were consulted together. We heard by a federal district judge in Missouri, but one case actually requested to be remanded to Missouri State Court, and they were approved to do that because the court said state tort law claims are the primary issues here, and there is no federal claim or federal question. And I won't get into all the civil procedure issues with what the court decided, but I think the big takeaways from this pretrial motion order to remand this case back to Missouri State Court and out of federal district court is related to the issue of preemption. So here, Monsanto is arguing that there are a couple federal laws involved, so they could keep the case with this multi-district litigation in federal court. But Monsanto specifically talked about how these laws, like FIFRA or the Plant Protection Act, preempt any state law claims. And with this, the court said, related to, of course, the civil procedure issues, it may not be relevant, but they did discuss how Monsanto could raise this preemption defense under either FIFRA or the Plant Protection Act, stating, of course, that you must prove either a label violation or some sort of violation under the PPA to show that Monsanto did violate these state tort law claims, and that federal law preempts any state tort law claims. So with this, that's something that will probably happen later on once the cases have reached maybe the trial stage. Expect Monsanto to raise that preemption defense, and it's possible that they will possibly succeed on that, just related to the analysis in this order. So with that, the status on this multi-district litigation, it's moving forward. There are going to be probably several more pretrial motions that the court will decide. So what happens with those will basically depend or have the outcome of which claims will actually be heard during trial by a jury. There are no dates currently set for hearings, so probably next year or maybe even the year after, there will be trials related to these class action lawsuits against the companies. So beyond the class action lawsuits, of course, there have been a number of lawsuits in the state of Arkansas, specifically suing their plant board, arguing that they're in violation of a regulation that prohibits the use of these new dicamba products from April 16th to October 31st. States do have the authority to enact their own law to revoke or suspend or cancel a pesticide registered under federal law, but they're arguing that the process that the plant board went through violated state law and some other issues related to the structure of the plant board. And so they're trying to get this ban removed. Several farmers and Monsanto, of course, too, in the state of Arkansas. So the status of these cases, the Monsanto lawsuit against the plant board was dismissed based on a sovereign immunity claim, which basically means that the plant board cannot be sued related to this claim. And an appeal has been filed, so just keep an eye on that and whether or not the court will hear that appeal or not. With the farmers that sued the plant board, that got a little complicated. There were a number of these lawsuits in circuit and county level courts in the state of Arkansas. Over 150 farmers were part of those lawsuits, and some of those judges actually ordered a temporary restraining order to get rid of the plant board's ban and their authority to enforce the ban. So potentially for a brief amount of time, there were a number of farmers in the state of Arkansas that could use these products, but the state appealed those judges' decisions all the way to actually the Arkansas Supreme Court, and the Supreme Court halted that restraining order and said that the plant board can continue to enforce the ban, basically talking about how state agencies like the plant board do have that sovereign immunity. So with this, that's something that the court wanted to keep in mind as these cases proceed, and they want to allow the plant board to continue to enforce that ban. So those new products are still banned in Arkansas for 2018. With that, these farmers, of course, are not currently able to use any of these products on those tolerant crops until an appeal is decided, and it's predicted that will take around 8 months right now. So just keep an eye on those appeals as well in the future. And with that, I think we can take questions.
Yes, if you have questions, go ahead and type them in either the chat box or the question and answer box. Oh, we have one question. And I guess it's for Tiffany with regarding liability of independent contractors. Is there a need for or value of professional liability insurance in addition to business liability insurance?
Ray, you may be over my head. I don't know that. I don't know the answer. If those kind of applicator services carry professional liability insurance, or if they just have general liability insurance, I would want to make sure they had some form of liability insurance for sure. On that note, I think it's also really important for anybody who's going to apply or have application done, make sure that your own farm liability policy covers spray application, and make sure there's no limitation in the fine print. I know at least here in Texas there are a couple of insurers that have a cap on spray drift damage of like $25,000, even on like $1 million policy. I mean, it's kind of in the fine print that there's a cap there. So I would sure check your own insurance. I would check to make sure that your applicator had insurance as well. As far as whether that needs to be professional liability insurance or business liability, that I don't know the answer to.
Any more questions? Give everybody another minute to see. If they have any questions. And I guess one thing to build on what you said, Tiffany, there are certain insurance companies that are starting to exclude dicamba from commercial applicators, aren't there?
Yeah, I mean, I think that the insurance companies have really been scrambling to try to deal with some of this, and I think there have been some exclusions. I think there have been some really increased rates if you want coverage for dicamba. So yeah, I think that's something that's sure happening, and I think there have been a lot of claim denials on the insurance front related to dicamba as well.
So I'm not seeing any more questions. So I will remind everybody that our next webinar in this series is, let me look at the date again and make sure I have it down, August 23rd, and we will have Professor Drew Kirshen with the University of Oklahoma, who's a professor emeritus there, and he's going to talk about biotechnology and how potential biotech coming on the market could change after the Syngenta cordancine settlement. So I think that'll be a very interesting webinar, but we'll send out reminders to all of you closer to that time. Thank you for, we have one last question. Can you quickly summarize the most important actions farmers can take to protect themselves?
I can take that one, Kelly, and feel free to jump in. Michael, are you asking about a farmer as an applicator or farmer as a neighbor potentially facing damage? I can probably answer both, frankly. I'll start with the applicator. If that's not your question, feel free to ask it again about the other way. But for an applicator, I think the most important thing you can do is make sure you follow that label. The easiest way to get liability, both civilly or regulatory fine liability, is to not follow the label. So I think number one, follow the label. Number two, talk to your neighbors. You probably need to know what's being grown around you. Are there any particularly sensitive crops? That chart that Matt showed I thought was a great one, you know, grapes, tomatoes, cotton. You need to know if those are in your area, whether you're being the applicator or if you're hiring somebody. You're probably going to know your neighborhood better than them. So I think, you know, talking to your neighbors, see what they've got as well. I don't know if every state has this. Paul, you can tell me about Maryland. Texas, we have something called a sensitive crop registry, where if you're growing grapes, for example, in cotton country, which we have a lot of here, you can go mark that on the registry, and anybody who's going to apply can go look on that registry to see what sensitive crops are in the area. And then the last thing I would really recommend is that insurance coverage that we talked about.
And we do have a sensitive crop registry, but it's 100% voluntary is my understanding. So
Yeah.
people get it in there, they don't check it, so there are issues with it. But
I guess I'll quickly, since we have just a couple more minutes here. On the flip side of that, if you're a farmer and you're concerned about spray drift, I think the most important thing you can do is document. If you start to see any trouble at all, the more records you have, the better. Pictures, but if you've got witness statements, if you've got notes about what happened, info on wind speeds, anything like that, even collecting samples. The more evidence type stuff you have, the better off you're going to be from an injury standpoint.
yeah, that's a really good point. Seeing no other questions, thank you all for attending, and thank you to the speakers for presenting today. So come back on August 23rd and we'll have a talk about the Syngenta corn seed settlement. So see you all then.